it is true, and I think this is the prevailing narrative, that the chief no longer has control. If the other 5 Republican appointees on the court want to do something, the chief doesn't have a lot of power to stop them. But I think that the chief's role has been understated. The chief has the assignment power, and he has exercised that quite muscularly in big cases. That's a huge contrast with his predecessor, Chief Justice Rehnquist, who I think was content to give himself the ERISA cases and to leave the big cases to others. This chief, as Justice Barrett recently said, likes to keep the big cases, and that gives him, I think, a great deal of control about how those cases are decided. And that having been said, again, he's not always able to control the rest of the court. The foremost example of that is Dobbs, where he would have upheld the Mississippi abortion law in question without revisiting Roe versus Wade. And I think there, you saw a really significant fracture. The other thing that I just want to mention parenthetically, and I know we're going to come back to this, is that that second era of the Roberts Court, from 2017 to the present day, coincides neatly with the rise of the shadow emergency interim motions docket. I'll call it the motions docket because that's really what it is, which in turn coincides with the rise of executive orders and other forms of unilateral executive action, really as the primary form of lawmaking in our country, with the disappearance of Congress. And that has posed enormous challenges for the court.